So people should be watching very closely what the provincial government does in the months and years to come, because could this be applied elsewhere in the province? Could other First Nations go to court and ask for and achieve the same type of decision and put people's private property in question?
Yes, on the basis of the Cowichan judgment, they could. They could challenge the private property interests. If a declaration of Aboriginal title issues from a court over those private lands, then what we know from her judgment, as long as it remains good law, and it is law today, what we know from her judgment is that the immediate effect of an Aboriginal title declaration over anybody's private property will be that the indefeasibility provisions that protect you under the Land Title Act have no application. So what have you got? You've got a fee simple which is thrown into question. The court hasn't gone so far as to declare it invalid. But what is it? It certainly is not protected, according to her, by the Land Title Act. So I'm not quite sure what you've got, but I'm pretty sure that it's diminished.
What should the public be demanding from their politicians at this crucial time?
My suggestion would be that the public should demand transparency from its provincial government. There's a lot of this that's been going on in total secrecy. Even the Freedom of Information legislation has created the ability for government to withhold any information that might affect Indigenous negotiations. So that means you can't even get access to this information through Freedom of Information. So I would say the secrecy is entirely problematic. And there are all kinds of negotiations going around the province where the government says it's negotiating Aboriginal title. Well, if it's doing what it did on Haida, that's truly frightening. But we know nothing about it. We're not told. And so I guess my last word for the public would be ask them, demand that they come clean as to what is going on.